My name is Tom Laurie. I work for Washington State Department of Ecology, and I've worked in Indian country for almost 40 years now. I grew up in Kitsap County. I worked in that county for a tribe for 12 years before coming down to Ecology, where I'm now the Senior Advisor for Tribal and Environmental Affairs to the Director. I'm going to try to accomplish three things today. Describing tribes generally in Washington State, give you kind of the big picture aspect to that, and then describe what we've learned about Indian water rights, which I don't think you're going to be dealing with directly, but it's part of the context, and then talk about some of the outstanding Indian water right issues before us. Neil mentioned the handouts. I invite you to download those at your leisure. There is the first one, Indian country terms, is actually very handy because you start throwing these things around and sometimes you think you know what they mean, and it's just good to have a reference as we're talking about trust land, that sort of thing. And that's laid out there in the Indian country terms. There's a rather extensive Washington tribe timeline that I put together. It's obviously not everything, but it's a good picture of the evolution of relationships, particularly in the recent years. So I encourage you to view that. There are two maps in there, one just showing the location of tribes, the other showing treaty-ceded areas, which we'll talk about a little bit here coming up. And then finally there's a spreadsheet with some of the tribal natural resource contacts in case you want to get a hold of somebody at the tribe. I reviewed that list. It looks like it's pretty accurate to me, but names will change. But you ought to be able to use that number and get to somebody in a natural resources division at a tribe if you're interested. So with that, I'm going to start with the slideshow here. I begin with these two photos, which are sort of my favorites because these are the people that I worked with in Kitsap County, the Clalams. One, of course, showing a historical photo, and the other I guess it's historical too. It's just more recent history. This is a tribe working on a longhouse that they built there now probably 8 years ago on the reservation. Yeah, so I like to remind people that there's been at least 12,000 years of occupancy here in Washington State by tribes. I mean, that's really based around glaciers affecting people living here, and those glaciers only came down to South Puget Sound, so could be many more years beyond that. But sometimes it's hard to keep that picture in your head. I mentioned the handout on Indian country terms. I'm not going to go into those right now, but we could come back to that if there are some questions about it, or if we need to, if we want to spend a little bit of time talking about the specifics. So one of the things I've tried to do is talk a little bit about what a tribe is and what a tribal member is, and we have to, you can't really do that without getting into the federal relationship, which I'll get into in a minute. But one of the difficulties sometimes in just discussing tribes is that, as I say here, the term Indian and tribe are both sort of technical terms and ethnological terms, and so they get incorporated different ways. The federal government has a formal recognition of tribal government process and have recognized over 560 tribes. And here in Washington State, I'll get to that in a minute, but we've had a few tribes recognized in very recent years. Many tribes are made up of confederated bands on a single reservation, and I'll mention a few of those in Washington State. You may be familiar with them, obviously. The big ones, of course, are Yakima and Colville. But there are some tribes, like the one I worked for, the Porgamble-Sklallam tribe, of which there are actually 3 Klallam tribes, separate entities. And at one point, I'm not sure if we'll be able to get into this or not, at one point the interest of the territorial governor of Washington State was to actually combine them all. So they would have been on a combined reservation. Didn't work out that way. The Bureau of Indian Affairs has a specific process for tribes seeking recognition. It is somewhat controversial. Right now in Congress, there's a couple bills that would take that power away from the Bureau of Indian Affairs and give it to Congress to do. So I'll be talking about sort of the history of the interaction with tribes that got us to this point, but it's important to realize it's not over. It's going on even as we speak. I guess I mentioned this. There's ethnic definitions and legal definitions for who is an Indian. Most tribes have a descendancy requirement in their tribal membership laws that may have a combination of a person being a descendant from a tribal member at treaty time, or when the last rolls were done by the Bureau of Indian Affairs, and they can have a blood degree requirement as well. Generally speaking, we think of an Indian as a member of an Indian tribe, an enrolled member, but oftentimes there are people with Indian descendancy, grown up in Indian culture, but are not members not formally members of an Indian tribe. Yeah, so this is one maybe to linger on a little bit. We have 29 tribes in Washington State. 29 tribes. 21 of them are what we call Stevens Treaty tribes. The rest are executive order tribes. And I mentioned recently recognized tribes. That's Samish up near Anacortes, Snoqualmie, they're at Nisqualmie, and Cowlitz, which just 2 weeks ago concluded a federal case challenging the establishment of their reservation down in La Grande, and they prevailed in that case. So their reservation looks like that's going to stand at that location. We have one executive order tribe, the Colville tribes, that had a land, they have ceded land that is somewhat like these Stevens treaties. They didn't sign a treaty, but they did cede land in a couple of actions. The 21 Stevens Treaty tribes are also fishing tribes, and they reserved in those treaties the right to fish, and we'll be talking about that a little bit later. But so these treaty tribes have treaty reserved rights, and there are a lot of implications for that, which I'll get to. And then I note that we have two tribes that are out of state, that's Nez Perce and Umatilla, that ceded land in Washington State under treaties to the federal government. Currently, Washington tribes employ over 27,000 people statewide and pay quite a bit in employee wages and benefits. And as you can just read from the slide, are very active in the business and economy of Washington State. I wanted to give a couple examples of tribes, and this isn't very, every tribe's a little bit different, I guess, but the two largest tribes, Colville and Yakima, you can see the number of tribes and bands that were brought together on that reservation. The size of the reservation, size of population, and the Indian population that is approximated on those reservations. The Suquamish tribe is quite a bit smaller reservation. They are located on Kitsap Peninsula, not far from the tribe I worked for, the Gamble tribe. And so smaller membership, but still quite a few non-Indians on that reservation. And this mix of non-Indians and Indians on a reservation has led to some very complicated legal issues, and I'll point to those a little bit later. But it's also a situation where you might find somebody, a non-member or a non-Indian on a reservation, might be seeking a water right that they feel does not, they don't need to go to the tribe to apply. And so this is just a little different formation of the map that is in your handouts. It's a map I use actually pretty often to think about what tribes might be affected by different things that Ecology is working on. Yeah, and so this is one of these places I wanted to pause. So that's sort of the opening introduction to tribes. Are there any questions, or shall I continue?
I'm not seeing anything that has come in on the chat. If anyone wants to ask a question with a microphone, we can turn the microphones on. I've got most of them muted because we did have some background noise, but other than that, I think you're good to go.
Okay. Well, feel free to jump in at any time. I'm trying to keep this pretty high level because I'm not sure what you need to know, but there's a lot of depth. I have a more general slideshow from which this is derived that goes into a lot more detail. I don't want to overburden you, so feel free to ask questions. I guess I got to click on this again. There we go. In order to understand our current relationship with tribes, you have to pay attention to the history. And it's kind of hard to imagine, but I mean, it's hard to think about the implications of this, but originally, Indian nations were not considered part of the United States. And you think about it in terms of the westward expansion, they were considered foreign nations, and were pushed west to a point until that couldn't happen anymore. And I think our era of treaty making in Washington State is what that led to. But if you want to understand the origins of the U.S. tribal relationship, you have to look originally at this European notion of discovery that was it was kind of an international law amongst the European nations at the time of the exploration by them of North America. You have to look at the U.S. Constitution, some of the seminal cases by the U.S. Supreme Court, of which the Marshall Trilogy is right at the heart, where Indian tribes became defined as domestic independent nations. And then the interpretations of federal authority over tribes. This is the congressional plenary power bullet there, and the federal trust relationship. All that stuff has helped to form what the relationships that we have today with tribes, and there's a lot of depth to each of these. But here's this slide is a fundamental question: is how did the U.S. acquire Indian lands? And treaty and purchase is the one we may be most familiar with. As I mentioned, 21 tribes in Washington State, 2 out-of-state tribes, were dealt with through treaties. and that's a peaceable land transfer. And in Washington State, one of the largest, or if not the largest, peaceable land transfer anywhere in the world happened with the treaties. But that was only 21 tribes in Washington State. There are 29. And how were those lands acquired? I mentioned what happened with the Colville a little bit. I may be able to get back into that. Those are executive order deals, very much like a treaty. But there was war as well. I think the Spokanes in particular went to war with the United States. And the rest of the land became U.S. land through the last two bullets there, claiming empty land and sort of an adverse possession. So we have a mix of history there in land acquisition from tribes to the United States. And I can talk about any of those in more detail. Here's one of the sad things that really paved the way for the European nations to become so dominant throughout North America, but certainly out here, and that's smallpox. Smallpox devastated Indian communities, and they preceded most of settlers coming out here. Smallpox preceded that. So settlers could come out to an area and it would appear, to all intents and purposes, to be empty. So they claimed empty land, basically. Not entirely, but tribes were just hugely diminished by smallpox and other diseases. The U.S. had originally a removal policy, moving the Indians from the east into western territories. And the Trail of Tears is one of the prominent examples of that. And then as the open country for relocating tribes was diminished by development pressure, settler pressure, the U.S. changed its approach to consolidating tribes on reservations, and that's the period of time when the treaties were negotiated out here in Washington State. There's a lot to each of these things, but in a very broad stroke, the federal government has had these sort of fluctuating policies on approaching tribes, assimilation, reorganization, termination, and then the current era that we're in, self-determination. And there's good and bad stuff that happened in all these eras, but it really affected tribal land base and the ability of the tribes to be cohesive units of government. Here's just an example of one of the initiatives from the federal government to encourage Indian people to leave reservations and come to areas of economic growth. Your chance of a lifetime. I have a note here on the federal plenary power. This can be important in some situations. I'm not sure it's really important for you all to know about in terms of conservancy board stuff, but it's I'm pretty sure this slideshow will be available to you to look at in more detail later. It's just the federal plenary power is a pretty important doctrine in our relationship with tribes. Basically, Congress holds the final cards when it comes to jurisdiction and powers. Got some notes coming up here on off-reservation allotments, and this is an area that you might run into. because there are a number of off-reservation allotments in Washington state, and they happened in a couple of ways. One is when a Indian land was diminished in some way, such as this example I have here with the Moses Columbia Reservation. When the executive order agreement diminished that land from basically the Cascade Mountains to the current boundary of the Colville Reservation, Indian people had a choice of accepting an allotment in their name on the reservation and sometimes getting cattle or other resources, or staying on the land that they were on if they had already made improvements on that land. So this is why we have Indian land on Lake Chelan, for example. There were Indian people of the Colville tribes living there, and they didn't want to move on to the Colville Reservation. They had built homes or developed agriculture or cattle or whatever along the lake, and they wanted to stay, and the executive order and the government allowed that, and those lands became what we call Indian allotments. There's another device that staying with allotments, generally, the General Allotment Act had a huge effect on tribes. You see the quote there from Teddy Roosevelt. I don't think that it was initially intended to divest tribes of land, but it became a great opportunity for many. The report that led to the General Allotment Act was really a social reformer report looking at poverty on reservations, and their answer was that individual tribal members needed to own land in order to have an incentive to improve that land, and that became a part of the Dawes Act, also known as the General Allotment Act, that divided reservation into individually owned tribal parcels, and those are also called allotments, but within the reservation. But it allowed the federal government to sell off what they called surplus lands, and it also allowed individual Indian members to sell their land, and it resulted in, as you can see, 90 million acres of tribal land lost. Very devastating, and it put a lot of non-Indians into reservations, and the consequences we're still dealing with today. And I just wanted to give you an example. So this is came across. I don't know where I came across this exactly, but I like this example because it's very local. This is Department of Interior selling Indian land. Here's a blow up from there, and this one of these, of course, I find very interesting. Port Madison Reservation, that's the Suquamish Reservation in Kitsap County. Here's an allotment owned by William Kitsap Jr. that is now for sale. So here's the Department of Interior selling it either on his behalf or on the behalf of his state. And Kitsap County, here's the not the namesake, but the family namesake for that county. The General Allotment Act, the divestiture of land from tribes and individual Indians was stopped with the Indian Reorganization Act in 1935. This act was called the Indian New Deal, and it truly was. It set up a process for tribal governments to work in a uniformed way. Some tribes didn't like that. They had traditional methods, and others accepted it, and some kind of did both. They kept some of their traditional governance methods while having, in addition, this more corporate form of government with elected council, etc. So because of these different policies and actions, we have these three basic kinds, or these two basic kinds of lands within Indian reservations. Land held in trust by the federal government for an individual or the tribe, and land owned in fee simple. And most oftentimes, that's held by non-members, but a tribal member or an Indian could own land in fee simple as well. And this has led to highly complicated civil and criminal jurisdiction. And sorting this stuff out is still going on. The Violence Against Women Act, which was passed last year, contained provisions for tribes asserting civil jurisdiction over non-members, and that was considered highly controversial during the passage of that act. It's being implemented somewhat slowly, but giving tribes more authority over domestic relations for non-Indians. And then back to off-reservation trust land. This is pretty interesting because there's different kinds of it out there. There are, as I mentioned, Indian allotments from diminished reservations, the Colville example. But we also have Indian homesteads that became and are called allotments as well. Nooksack had a number of these, Yakima as well. When the federal government was allowing non-Indians to come in homestead lands, they also had provisions that allowed Indian people to do the same, and that land could be taken into trust by the federal government. We have here, not far from Olympia, an area that is off-reservation trust land that has been designated a dependent Indian community, Frank's Landing, the site of many of the Bolt protests, which I'll get into a little bit. Along the Columbia River, there are a number of fishing sites that the federal government bought and hold in trust for the fishing tribes of the Columbia River. They're called fishing in lieu sites, which because they provide access to fishing that was lost when the dams were installed and flooded the traditional fishing areas for those tribes. And then we have really, I don't know if anybody's got a quantity here as the amount of land. Well, we have land that is taken into trust off reservation for tribes. And maybe I should clarify that right now. Tribes can buy land, of course, anywhere. Anybody can buy land. But many times they would like that land taken into trust, which removes it from the local tax rolls and provides them more of a direct jurisdiction over that land. So some tribes will buy land and have a portion of it or all of it, if they can, taken into trust. But that's a very lengthy process. So sometimes you have to buy land and hold it for a while before that can happen. I don't know what the off-reservation land holdings of tribes are generally, but we see land taken into trust pretty regularly. And there are some interesting jurisdictional and water rights questions around those lands, and I'll talk about those in a little bit. But they can be brought into trust. This is another area that is currently under controversy with Congress because some of these lands could be used for gaming and casinos, and that's of concern to a lot of people. I won't go into the detail there, but I'd be happy to answer questions if somebody has them. I'll get into a little bit of that when I talk about water rights coming up here. Oh, yeah, another pause point. Am I going too fast?
We actually do have a question.
As long as it's not from an ecology person.
And Julia, I know you have a microphone if you want to just go ahead and ask that one with your mic.
Yeah, Tom, I just wanted to see if you could sort of expound on when you're talking about land held in trust, are all the related resources included with that parcel, especially water rights? Are the water rights also held in trust? Because what bit I know about when working in Yakima, that I believe the federal government works with the tribes, but the federal government did not surrender all aspects of managing water rights on tribal lands, as I understand it. Perhaps you can get detailed about that for us.
Yes, I can, Julie. It's actually a little bit later in the slideshow, so let's defer that. If I don't get quite to it, tell me again. But I've got some stuff leading up to that, so let me run through that. And
yeah, sure. Thanks.
Looking at the clock here, I may have to. I got a few more of the general things, and then we'll get into treaty rights and water rights.
Okay, and what kind of fish is this swimming across the roadway?
I think it's a sockeye. Why did the fish cross the road?
Thanks, Tom.
Oop. Click again. There we go. I wanted to talk just briefly about jurisdiction within an Indian reservation. A whole lot of case law around this. You can read this in a little bit more detail, but the Supreme Court said that in some cases tribes do have direct inherent jurisdiction over non-members. Of course, it's an area that is tested time and time again, and there's been a whole string of cases around it, which I could describe in more detail. For the environmental laws, these are ones that, of course, Washington State as a state deals with quite a bit because we're delegated for all these programs in Washington State, except within Indian reservations, with one exception, being the Puyallup tribe. So this is just a list of the federal laws that have provisions in them for tribal delegation, where EPA can delegate directly to tribal governments. And a number of tribes have received delegation for Clean Water Act programs, and there are 9 of them that have taken on setting water quality standards. And this can be significant because it puts a burden on upstream dischargers to meet the tribe's water quality standards when the waters flow across those borders, much like water flowing between states. In fact, the EPA process is called treatment as a state for tribes. Okay, fishing rights. This may be something that you're pretty familiar with because it's been such a big deal here in Washington State. There are a couple different aspects of it. I'm going to focus on the fishing ones. Bolt 1 was what I call the fisheries share. That's where Judge Bolt determined that when the tribes signed the treaties, they believed they were reserving the right to take 50% of the fish. And the government, the U.S. government, is presumed to have bargained in good faith. The Bolt 2 is ongoing. It's a question of what is the environmental requirements for not violating the treaties. Some people call that environmental servitude associated with the treaties. And that case is being litigated right now. Just last month, the Ninth Circuit heard an appeal in a case having to do with the state's obligation to preserve habitat for fish. This is the paragraph in one of the treaties, Treaty of Point No Point, where the fishing, where the tribes reserving the right to fish is stated. And this is very similar language to the other Stevens treaties, which is the Treaty of Yakima, the Treaty of Medicine Creek, Point Elliott Treaty. The Macaw Treaty includes a provision like this, but adds additionally the right to whaling. And so this is just kind of a little history of the Volk decision. This is getting into kind of how we got into fisheries co-management. We, for a period of time, had the federal court actually setting gear limits and seasons on fishing because the state was not able to do so without violating the tribe's rights. So, the state would do something like they'd create a fishing regulation for the season that would be beneficial to large commercial vessels, whereas most of the tribes had small boats that caught the fish when they got close to their spawning areas at the mouths of rivers or bays. So the state would and could promulgate these regulations, but the tribes would say, hey, that's not fair, you're going to catch all these fish before they get to us. They'd go back to the court would side with the tribes, and then it would do the regulations. So it was a pretty sad state of affairs until Bill Wilkerson, who was the director of state fisheries, decided we needed a better way, and that became the co-management framework that we have today for setting the fish catch standards and regulations seasonally, as we do now with tribes. Here's a little bit more about what followed when after Judge Bolt made his decision on the share. He said the environmental issues will have to be decided in a second phase, and that became known as Phase 2, Bull Phase 2. And Judge Orwick was the first judge to rule on that. So going back to Judge Orwick, he made a very generalized ruling about environmental obligations. When it got to the Ninth Circuit ultimately ruled that it wasn't the type of legal question that could be decided in general. It had to be determined by the facts of a specific case. So the Ninth Circuit turned it back to the district court and said, wait till you get a specific case. It took a long time for that to happen, but it did with the filing of the Culvert case, which is the one that I just mentioned, the Ninth Circuit just heard about. And this is where tribes have argued that the state cannot have a right to maintain and use culverts that block fish from their habitat because it kills fish. In fact, Orwick said in his original decision, Judge Orwick said, well, if you can't take the fish directly from the tribes because it's their right, you can't take them indirectly from the tribes by denying the fish the habitat. So that's kind of the premise of the Culvert case. And as I say, that went up on appeal to the Ninth Circuit last month. And here's more detail about it. I'm going to skip it so we have a little bit more time to talk about water rights. Here's a little list. Just because we're in court over a lot of things with tribes, we have a lot of good things going on with tribes too, so I don't want to diminish that, and I'll be happy to talk about those. I'm going to skip questions here because I want to get to Julie's, unless somebody's got something burning. So let's go back to the genesis of tribal water rights. Very briefly, it was a 1908 case called Winters. Upstream users were diverting water that was to go on to a reservation, and it went up to the U.S. Supreme Court, and the Supreme Court said that there was an implicit water right associated with the creation of a reservation, because why would the federal government create a reservation that would otherwise be useless? And why would tribes agree to that if it didn't have water associated? So that water rights were implicitly created at the time the reservation was created. They have a number of differences from state water rights. Big one is this first bullet: they are not lost if unused, so they are not relinquished. So this is an outstanding potential burden on water resources, these unadjudicated tribal water rights. And they are perfected as of the date of the reservation or time immemorial if they're based on treaties. In order to quantify a tribe's water right, the courts have looked at, well, what is the purpose of the reservation? And here's a list of some of the things that they've looked at for quantifying tribes' water rights. Far and wide, the most used metric for quantifying tribal water rights is this thing called practically irrigable acres, because many reservations were created to be a permanent homeland and encourage farming. So you'd look at, the courts have looked at how much land is there that is practically irrigable and come up with a quantity from that. There are other tribal reservation uses that that have been recognized, and fisheries is one of those in Washington State. So here's just a list of some of the differences between the Indian water rights and state-based water rights. And it gets complicated with, let's see if so here's an example, though, of, what I'm getting to here is just to mention the Walton case on the Colville Reservation. It's a long federal case that ultimately concluded that a non-member did, in fact, have a water right associated with a piece of land they bought that was a former allotment, tribal member allotment. That land had a piece, basically, of the overall water right of the whole reservation, and that if the non-Indian owner maintained that water in a manner similar to the state requirements, that water stayed with that parcel. And this land within Indian reservations with agriculture this is what this picture is all about, encouraging non-Indians to consider agriculture on Indian lands. Yeah, this is more detail about what I was just saying. The allottees' right, they're sometimes called Walton rights because that was the name of the case on the Colville Reservation. The issue of regulatory jurisdiction gets all the way back to some of these first slides that I shared, having to do with the authority of tribes over non-members. And there's a lot of unknown there as to how that might work. We have some case law here about tribes trying to assert water code jurisdiction over non-members on the Yakima Reservation. This example here of No Name Creek, that's a situation where the court determined that the state did not have a jurisdictional interest in No Name Creek because it rises and falls completely within the Colville Reservation. Yeah, so here's the question I think that Julie was asking about a little bit, and that is, what is the do water rights stay with trust land? on and off the reservation maybe, and you might put a finer point on it, Julie, if you'd like, after I describe this. So when you have off-reservation trust land, and we had a good example in Airway Heights near Spokane, where the Spokane tribe had bought land in Airway Heights and wanted to develop it and was set to put in their own well to do so. I forget the exact year that they bought the land or had the land brought into trust, but I think it was around the year 2000. But they were going ahead under their own authority just to put a well in. And that was a problem for the state and for the people of that area because that's a closed basin. There's actual conflict between water users over a very limited water supply. And here comes the tribe that may exacerbate that problem by just doing in their own well. The tribe reasoned that they had this right two ways, one being a sovereign entity, but also because they felt this was Aboriginal land and they had a right that dated for time immemorial. The state believed, and I think we do pretty solidly believe, that if there is a water right associated with this land, it would date from the date it was brought into trust. That is, from the year 2000. Therefore, it'd be junior to everybody else in that basin, really. The problem for the state in these situations is that the tribe is a sovereign entity, can't be brought to court independently, and our only mechanism for bringing the tribes into court is under a general adjudication. So it's got to be a comprehensive adjudication of a whole basin. And if we do that, we can use the McCarran Amendment to bring in the federal government and the tribe. Very expensive way to deal with, one well, for instance, or one activity. But that's assuming that there is a water right associated with this off-reservation trust land. And I don't think we have any case law that provides a definitive answer there. I think it's highly possible, though, myself, that there is a water right, but this jurisdictional in terms of managing it or quantifying it puts us back into an adjudication as the only tool I think we have in the toolbox at the moment. Julie, you were asking about on-reservation land, and what was that?
I'm just wondering, does the federal government have any purview over water on any tribal lands in Washington State? Seems to me they reserve certain rights to manage water that flows through tribal lands, but I could be way off on that.
Yeah, I'd say the answer is no. I don't think the federal government has asserted a regulatory right over water quantity within the reservation. But inasmuch as the lands are federal trust lands, that's land held by the federal government in trust. Those are federal water rights. But they have deferred to tribal water quantity management. On the quality side, water quality, Clean Water Act, they do assert jurisdiction through EPA. And as I mentioned, tribes can take those programs on directly if they want.
Thanks, Tom.
Yeah, so here are some of the puzzlements before us on Indian water rights. And I mentioned some of these talking about the Spokane example at Airway Heights. And besides, I should just mention the Airway Heights situation was resolved when the tribe did put a well in, did not find water, and then approached Airway Heights to see if they could get on the municipal water, and they were able to. Many of you may be aware of the ongoing adjudication in the Yakima Basin, Aquavella. There have been some conclusions as to the tribal water rights associated with that water, and here's a list of them. And it includes water for fish. And the water rights associated with fisheries, which was a right the tribes had before treaties, during treaties, and after treaties, is considered time immemorial. That's in contrast to an agricultural right that may have been created at the time the reservation was created, 1855 or 56. So in the Aquavella case, the tribal right to water for fisheries does include off-reservation streams. In a broader context, here's a question that is not legally resolved. It's related to this culvert case. Do federally reserved water rights apply to off-reservation treaty fisheries? And as I note here, both the Lummi and Nooksack tribe have asked the Department of Interior to litigate, to quantify their treaty fishing rights, or treaty fishing and water rights in the Nooksack Basin, so the off-reservation component. If you haven't listened, if you're interested in this line, the Ninth Circuit's hearing oral arguments on the culvert case, which was last month, is available on archive. And it's a very interesting hearing. It's a 3-judge panel of the Ninth Circuit hearing from the tribes and federal government as to why culverts that fish block are a violation of Indian treaties, and the state arguing that that goes too far, that there's not an absolute right to no impact to fish. But the judges, if you listen to that, you'll hear them saying, well, what about dams? What about water? What about shade and temperature? That's when they're probing how far are you saying the tribal treaty fisheries rights go? And on the other side, they're probing the state, saying, does this mean you can just destroy the fisheries and not violate the treaties? So it's a very interesting conversation, and it just kind of shows you how this stuff is very real, very alive, and I don't know when we might expect a decision out of them, but it's even though it may get appealed, we'll have another slide down the road on this. And I think that's it, pretty much. I've got a couple more slides in here I won't even go to. Well, just jump past them quickly, about a bill that passed the legislature requiring state agencies to communicate and coordinate to the extent possible with tribes. It sort of formalizes in state law what we call the Centennial Accord, which I didn't get into, but the Centennial Accord was a mutual recognition of government-to-government relations between the state of Washington and tribes of Washington State, and there's just some bullets here on it. And this is my closing one showing a huckleberry picker, I think, on the Yakima, on Mount Adams, and a gooey duck picker out in the San Juan Islands area. And that concludes my stuff. Lots of handouts. Be happy to answer questions about that. I think we must be just about out of time, but people can contact me directly too. I don't know if my phone number is available on the materials, but it is at the Ecology website.
Yes, Tom, your phone and email are on the overall agenda that the Conservancy Board folks have received.
Yeah, I'd be happy to talk with anybody in more detail about all of this, whether related to Conservancy Board or not. I think it's just good stuff to try to know and to understand the context that we're in.
Okay, great presentation, fascinating information. At this point, Anyone with a microphone, click on your hand raise icon, raise your hand if you have a question and you'd like to ask that question verbally. I know we're right at the top of the hour. And it looks like a couple of people are dropping off. Before you go, I'd like to remind you that your work isn't done. There is an evaluation. If you could please go ahead and click on that, or actually it will pop up on your screen as soon as you log out. And if it doesn't, you'll have another chance tomorrow because you'll be getting that day after email with your certificate. We've been having some formatting problems with the certificates. For that, I apologize. It's nothing that we have any control over. Go to the Citrix platform is working on that bug, but for now they haven't fixed it. But again, anyone with a question with a microphone, we'll turn the microphones on. And if not, Julia, any closing remarks or comments?
Well, I actually have a question for Tom. After the once we hear the sort of the response from the court on the culvert case, do you see other legal issues brewing that are going to be, you know, the next front and center issues that we'll be hearing about?
Well, the culvert case is likely to go on. I guess the court could rule in a couple different ways. They could rule, one, that, well, in this specific case, it is a violation of treaties, but they will have to separately evaluate any other claims, like does a dam violate, you know, a fish blocking dam violate the treaty or other things. So that could keep on going. But another issue that's kind of big for Washington State has to do with taxation within Indian reservations. The Tulalip tribes have filed a case saying that their retail development, which they call Quilceda Village, there along I-5, should not be taxed by the state, that those businesses should not be taxed by the state, that they should instead be taxed by the tribe. And that's going to be a big jurisdictional case.
Yeah, that's a huge development. It includes a casino too, doesn't it?
Yes. Yeah, well, the casino isn't taxed, so I don't think that's the issue. But, you know, like Home Depot and all those businesses there.
Huh. Wow. Okay. Well, thank you, Tom, so much.
Thank you, and Neil, thank you. You guys made this very easy to do.